My name is David Wilkins. I am the faculty director of the Center on the Legal Profession. I've been teaching here for many years. I'm technically on sabbatical this year, which means I should be on some beach in Brazil where our friend Oscar's from, but instead, I'm actually doing something much more interesting and thinking about really one of the most, I think maybe the most important thing we could be thinking about as lawyers. The Center, for those of you who don't know, is an empirical research institution kind of dedicated to studying the legal profession, your careers, globalization, the rise of technology, the institutional structures and economics of law practice, career trajectories, all kinds of things like that, in the hope that it will actually help you to make better decisions about your own career, to help you to think more deeply about what the purpose of the legal profession is. And we do this not just for students, but also for professionals. And we've also, I started many years ago, a kind of executive education program in which we have many leading lawyers come through here for various short courses. We also publish a digital magazine called The Practice, and Dana Walters sitting there is our lead writer on The Practice, comes out every other month, takes on a different issue. The last issue was a fantastic one on immigration lawyers. Brian Fong, who's standing there, is the real editor of The Practice. I'm kind of the fake editor, but he's the one that really does the work, as well as being the executive director of the center. We are delighted to co-sponsor this with the American Constitution Society for Law and Policy, and we are especially delighted to have all of you here when there's a lot going on, not just academically, but there's at least like 10 other events going on. But I promise you made the right choice and you came to the best one. Just a couple more quick housekeeping things. The event will be recorded, just so that you all know, and we have a number of terrific presentations, which I'll just run through very quickly, but there will be time at the end of the program for questions. Listen, you know, the title of this is Do Legal Professions Resist Authoritarianism? Case Studies on US, Brazil, Russia, and More. And included in this topic is not just do legal professionals resist, but how might they enable what is sometimes thought of as authoritarian impulses, even in societies that are technically still democracies. I think we all know something about this, no matter where we are in the world. So I said we didn't just arrange this to be on the day after John Eastman got disbarred, but it certainly is obviously relevant to what's happening here in the United States. But I just came back from India, as I was talking to some of you about, where these issues are very much on the agenda. About a month before that, I was in Brazil. And you'll hear more about Brazil here, in which these issues are very much on the agenda. And I've been in communication with many people in China, which you will also hear. All of these countries were countries we studied in the project, our ongoing study on globalization, lawyers, and emerging economies, or GLEE, as we like to call it. And if any of you are interested in these countries or other countries in these issues or others, I hope you'll contact Brian. Are we going to send around a sign-up sheet for anybody who wants to be on our mailing list? We do a number of events. We've got an event coming up in a couple of weeks around a 20-year longitudinal study of lawyer careers, the longest, most in-depth thing that has ever been done, and the longest in-depth thing I hope to ever do, and a number of other projects that we hope will be helpful. Just to give you a kind of run of show, I'm going to introduce in a second my friend and mentor, Dave Trubek, who's kind of one of the many leading inspirations behind this project, and also was my collaborator on the GLEE project. We're then going to talk about the United States, both in terms of resisting but also enabling autocratic legalism, a term you'll hear about in a second. We'll then move to Brazil, and then we'll move to Russia. And then we'll have a terrific kind of comparison between the US, China, and Brazil by Leah Croyd, who's now, I just found out, a newly minted assistant professor at Syracuse, is now a fellow at Stanford. So as I said, there'll be time for question and answers afterwards, but thank you all for being here, and now on with the show. Dave, here, let me help. Don't worry, gotcha.
You can speak from there.
You can speak from there, well, but he's gotta get off the podium.
I gotta get off
Yeah.
sooner.
Yeah, here you go. Got it, perfect. Thank you.
You're gonna help me with it.
Yeah, I'll be.
Okay, it's working, yes.
Yes.
So I'm Dave Trubek, and I'm a professor emeritus at the University of Wisconsin, and I'm one of the members of the team called LAD, Lawyers and Democratic Decline. What you are listening to today are some preliminary papers from this newly formed project that is designed to answer some of the questions that David raised. As I said in the class yesterday, and some of you are here, I've got good news and bad news. Lawyers are becoming much more important in world politics than they have been in the past. That's the good news. The bad news is that the reason this is happening is that they're fighting over the rise of authoritarianism. But lawyers are not only involved in promoting authoritarianism, as they are in many countries, but they are also at the center of the struggle over autocracy and the process of democratic decline. Because law is a tool for autocrats. This is a new form of autocracy where instead of using tanks to take power, they use law. And law and lawyers are engaged in repressing opposition and enforcing autocratic policies. So those who are resisting autocracy have to use the law as a tool for resistance and turn to lawyers to assist them in these efforts. And in many cases, the lawyers are leading these efforts. So we know a little bit about what lawyers are doing for and against autocracy in a number of countries, but we need more systematic research in order to fully understand the challenge and find ways to strengthen resistance to the autocratic process. We need to understand what lawyers are doing and why they're doing it, and where they stand on the spectrum of democracy and autocracy. And to meet those challenges, a number of us from several countries have created this new research endeavor, which we are doing in conjunction with the Harvard Center, and we're very honored to have been invited here to make our initial presentations on lawyers and autocracy. And so today you'll be hearing preliminary results from 3 countries and some efforts at a first cut at comparison. So welcome, and
Thank you. And everyone will kind of introduce themselves as they come. Okay. Yeah. Yeah. Everybody knows who you are. International man.
Oh, you're good. It's already.
Okay, so thank you all. My name is Scott Cummings. I teach at UCLA and am spending the year in Florence doing research on this very topic. I feel very honored and humbled to speak between 2 of my intellectual heroes and mentors, Dave Trubek and Rick Abel, and I'm very grateful to David Wilkins and Brian Fong for facilitating this event, as always, and lending the resources of Harvard to support this project. So my assignment here is to talk about the role of lawyers in the decline of American democracy in 15 minutes or less. So I'm on the side of talking about lawyers as enablers or facilitators of authoritarianism, and then I'm going to be followed by Rick Abel, who will talk about resistance. I've been researching this topic in relationship to a larger comparative project on the role of lawyers in democratic backsliding. So far, I've gone into a deep dive into the 2020 election, which will be the focus of my comments today, and I'm beginning research on Hungary, where I just spent a couple of weeks interviewing lawyers. So in the paper that I circulated for the conference, which I think just went to our internal group, but that's coming out on lawyers in backsliding democracy, I suggest that up to now the literature on autocratic legalism, which Dave Trubek just mentioned, has focused on how political leaders, sort of the autocrats, cloak their actions in the legitimacy of law, giving very little attention to the actors who are required to confer that legitimacy, who are lawyers. So thinking about lawyers draws attention, I suggest, to the professional paradox at the center of autocratic legalism, which is why lawyers who are sworn to uphold the rule of law choose to attack it. And importantly for my discussion today, I'm interested in how lawyers attack it, right? How do they mobilize legal authority to develop the theories, file the cases, and write the laws to destabilize democracy. As everyone here knows, we in the U.S. have access, unfortunately, to this unprecedented evidence of what lawyers in fact do in the case of the 2020 presidential election campaign. Obviously, enormous attention has focused and continues to focus on the election attack, which I want to talk about, but first I'd like to place it into a wider context. Conceptually, in terms of what we mean when we talk about democratic or rule of law backsliding and attacks on democracy, I put forward this minimalist definition of democracy to kind of orient the discussion, focused on free and fair elections, the kind of democratic element, fundamental rights protection, especially for political speech and voting, and sort of the rule of law elements, checks and balances, particularly judicial independence. I propose this idea of anti-democratic legal mobilization as the use of legal strategies in court, but also importantly, I think, behind the scenes, to attack the legitimacy of these core features, to break down the guardrails ultimately designed to prevent abuse of power and to keep the system viable over time. In the paper that I have out, I offer this framework to trace mobilization along two different pathways to autocratization, the sort of slow road of democratic decline and the fast track of democratic collapse. The basic idea of the framework is to say that at each step along these pathways, we should be able to find lawyers doing the things that lawyers do, right? Designing the legal theories, filing the cases, and drafting the laws that weaken the elements that I just described. And as you can see from this depiction, maybe up at the top, elections obviously are key targets of autocratization on both pathways, precisely because democratic legitimation is essential to legal autocrats who typically use election mandates to justify rescinding constitutional constraints on their power, which takes me to my main question for today, which is, what are the strategies of election attack, right? What are the legal mobilization strategies of election attack? Of course, there is no one model. It depends on context. That sort of old school method is to get corrupt voting officials to stuff the ballot box. New autocrats are more subtle. They do it maybe like Hungary, where one party gains enough power to rewrite law, to gerrymander districts, change the vote counting rules, suppress opposition, and by this assure a permanent electoral success. The Stop the Steal campaign was different. It was kind of like the old school method, an effort to steal the election despite the name, but kind of following the new autocrats, it purported to do so in the name of upholding law. So ultimately, it sought to undermine public confidence, to create a crisis justifying Trump's exercise of extraordinary power, right? Staying in office despite losing. And key to this effort was that it was cast not as a subversion of law, but as a validation of law, right? A way to enforce election rules that no one else would. This created what I suggest was a cycle of distrust and continues to really be a cycle of distrust. And while this effort required a president willing to violate existing constraints to cling to power, and so really dependent in some respects on the maybe sui generis nature of Trump, it could not have gotten to the point it did just by the will of one person, no matter how forceful. I think as the autocratic legalism literature teaches, autocratic strategy works because there are already conditions of possibility, right? In this case, I want to highlight two such conditions that were in the background. The first condition was that the seeds for election distrust had already been planted well before Trump began to claim that he could only lose the election if it were, quote, rigged. The public was already primed to view voting fraud as a systemic problem that was not being adequately addressed by the legal system. As my colleague Rick Hasen has demonstrated, this voting fraud movement started almost 25 years ago after the famous Florida recount in Bush v. Gore. And this fraud movement kind of took off as a way to ensure that Florida and other battleground states would stay solidly Republican. A key part of the strategy is a public relations campaign to situate the conservative movement as defender of election integrity, which critics suggest has led to voter suppression, particularly in these battleground states. Another part of the strategy is a legal campaign. So in the context of 2020, fraud concerns were targeted to the integrity of mail-in ballots, particularly as states began liberalizing rules in the face of COVID, and Trump told his supporters not to use mail-in ballots. So even before the election itself, the ground had been laid for election distrust, and there were numerous pre-election lawsuits challenging the validity of liberalized voting rules in these key battleground states. Which leads to the second background condition, the second condition of possibility, which is the existence of strong legal networks already in place with expertise and resources. So this is more than I'm going to have time for in the presentation. Happy to talk about it in the Q&A. But the short version is that the mainstream conservative legal movement, with the Federalist Society as a key intermediary, influenced the composition of top lawyers in the Trump White House and DOJ from the early days of the Trump administration, and then was heavily involved in recruitment efforts for Lawyers for Trump, which was a group set up before the election to bring together lawyers from battleground states to litigate in the event that Trump lost. Key members of this group included Giuliani, Leonard Leo of FedSoc, Ken Paxton, Texas Attorney General, William Consovoy from a boutique firm that represented the RNC and other causes in DC. And in preparing for the election, this Lawyers for Trump team recruited lawyers from Big Law, Jones Day, King and Spalding, election firms like Pennsylvania's Porter Wright, which was very key in that state's challenges, small and solo lawyers, and some non-governmental organizations, including groups like the Thomas More Society and the Great Lakes Legal Center. As everyone knows, then came the election, too close to call in these 6 battleground states, and between November 3rd and January 6th, lawyers working with the Trump campaign and some working outside of the campaign filed roughly 60 lawsuits challenging the results. I think the way to think about these suits is sort of as a story of the genie escaping from the bottle. The fraud narrative's already there, and there are lawyers already in place, some of whom have demonstrated a willingness, not all, but some of whom have demonstrated a willingness to press claims in the absence of evidence or on very thin evidence. If you look at the cases in the first roughly 10 days after the election, there were sort of two groups. On one side, there were aggressive but legitimate challenges to voting procedures, mostly under technical provisions of state laws related to things like signature verification and poll watching. A few brought in Pennsylvania by this law firm, Porter Wright, that has a leading election lawyer. The cases were not about fraud, and ultimately the legitimate firms like Porter Wright pulled out, in effect, because the campaign wanted to press the fraud issue after the cases in this first wave collapsed. The second group of cases in the first wave actually did allege fraud or problems with voting machines or procedures that were sort of associated with fraud, and these were brought by what I would call MAGA movement lawyers. They included Alex Kolodin, a solo lawyer in Phoenix who filed 2 of the earlier notorious lawsuits in Arizona, the so-called Sharpiegate suits, alleging voters were forced to use Sharpies to mark their ballots, and that made them unreadable in these machines that were ultimately malfunctioning in ways that compromised the election. Interestingly, sort of Culloden was later endorsed by Trump in a successful bid to become a member of the Arizona legislature, which he won in 2022, and then he was put on probation by the Arizona State Bar for his involvement in the 2020 election. So this goes to the who question, like who are the lawyers and what their motivation was, which I think is an important topic for us to discuss today. By mid-November, the legal campaign sort of becomes a story of mainstream lawyers stepping back, more radical movement lawyers from these solo and small firm in battleground states, joined eventually by AGs like Paxton with his Supreme Court suit against Pennsylvania, sort of taking over in a context where it's not possible to exert total legal control. After the infamous November 19th Giuliani and Powell press conference launching the elite strike force, which all of you will remember, cases became much more extreme and not just the Kraken cases. And we see lawyers primarily from solo and small firms, many from non-urban parts of battleground states with no prior election law experience, in some cases assisted by these conservative legal nonprofits, also not known for election law. It's at this point the case has really shifted, at least from some of them seeking legal victory on the merits to a very different objective, which was creating a public narrative of ongoing disputes of illegal conduct by the states. And this was done to advance the last part of the plan, which I know you all are also familiar with, but important to make the connection, this so-called alternative elector plan, creating a scheme for advancing a dual slate of Trump-pledged electors before the state electoral college certification date of December 14th. This extraordinary legal plan centered on the production of legal memos by two lawyers, Ken Chesbrough and John Eastman, is pictured here, which purported to provide a legal roadmap to mimic the legal rules of election certification as part of a plan to persuade the vice president to exercise what was presented as his constitutional authority to not count Biden electors and deliver the election to Trump. You may have seen, as Professor Wilkins just indicated, that Eastman was just recommended for disbarment by the California State Bar Court in a 125-page opinion based on this scheme. And the point that it underscores is that the goal of the coordinated effort between the lawsuits and the memos was keeping the public narrative of fraud alive, keeping some lawsuits in play to create the appearance of a legitimate legal contest, justifying Pence's rejection of the Biden electors. And of course, when these suits failed, Trump moved to the last step in this cycle that I presented, which is trying to co-opt the government lawyers whose job it was to be independent and to keep him within the legal guardrails. And this centered on Jeffrey Clark, on Wright, also being prosecuted for ethics violations in DC, then a little-known Justice Department lawyer now indicted in Georgia for allegedly agreeing to become head of the department and then circumventing existing leadership in order to pull its full weight behind the false claims of election fraud in the 2020 election. So what does this effort teach? How is it relevant to this broader discussion about autocratic legalism? I mean, one important kind of finding, as I have already suggested, is that the use of law and this sort of stop the steal was not ultimately about being right on the legal merits, as you know. It was about tapping into the symbolic power of law to create the appearance of illegality, to justify this extraordinary remedy of refusing to permit the peaceful transition of power. And this idea of extraordinary remedy or emergency powers is something that we see across this kind of autocratic legalism literature. In my paper, I document how claims in the lawsuits were coordinated with media strategies in a way that attempted to blend fact and fiction. What mattered was convincing people that the law was broken, not ultimately convincing judges. Other key takeaways, as I've already suggested, these background conditions matter, right? What happened before the direct attack can lay the groundwork legally and politically and produce unintended consequences, right? Supplying kind of radicalized lawyers willing to cross lines within these pre-existing legal networks. So I think as researchers, we have to think about how longer-term political and professional trends create these conditions of possibility for authoritarianism to take root. Lawyers matter at every stage, right? Using law to promote distrust of legitimate legal outcomes. The lawyers in these cases, right, lent their legal prestige. They produced these facially legitimate legal work product, the briefs, the opinions, legal forms, to undercut the legal principles on which they were based. And some key lawyers in the conservative legal network became supercharged, right, willing to go beyond where the mainstream lawyers were willing to go. Most of these lawyers came from the non-elite sector, so I think one interesting question to explore is whether sort of lawyers further away from the mainstream profession may be more susceptible to recruitment into radical causes. And then finally, I think as a segue to Rick, while spotlighting the bad lawyers, the case also shows that legal resistance does matter, right? This was a Democratic near miss. Ultimately, the Stop the Steal campaign was foiled by the decisions of judges to systematically reject the campaign's post-election challenges and of some lawyers within the Trump administration who performed their gatekeeping roles adequately under enormous counterpressure. But the serious damage done to public trust continues, and that creates ongoing democratic risk. Obviously, most Republicans still believe the election was stolen. Trump's the Republican candidate for November, and there's reporting that his Trump team is vetting new lawyers who are more loyal to the MAGA movement and committed to a more subversive agenda should he win again, sort of putting them precisely in these gatekeeper positions that held firm the last time around. So with that, I'm going to turn it over to Rick.
I'm going to take the podium in a second, but before I do that, let me just pass out the following. So my talk today in 12 minutes is the condensation of 1,000 pages of books. Here are the three of the 4 books, and here are flyers. So take a flyer, look at the books. Well, thanks again to David Wilkins for hosting us, to Dave Trubek and the group for the comparative studies, which are enormously valuable. And of course, I'm delighted to follow Scott. We have been collaborators at UCLA over several decades. We didn't collaborate in this project, but we complement each other. Scott was writing in Florence, I was writing in Los Angeles, but I think the two will fit together. The U.S. has over 2 centuries of experience in deploying the law against autocracy, drafting and amending the Constitution, forming bar associations, creating the civil service, federalizing legal aid, establishing and expanding public interest law, encouraging pro bono, all of these aided by a host of social movements. These institutions have had to confront numerous challenges, including the abuse of Native Americans, slavery, the Civil War, Jim Crow, McCarthyism, 2 world wars, the Korean, Vietnam, and Afghanistan and Iraq wars. That's a long history. Nevertheless, I believe that the greatest threat to liberal democracy in America during my 80-plus years has been Trump's presidency and the threat of another term. I don't say that lightly, and I realize it may be a hard argument. I'm very interested in the Q&A, how you feel about that. I've written the 3 books, as I said, and I'm going to try to summarize them today. I'm working on a 4th book about how to hold autocrats accountable, which will narrate the story from January 6, 2021 through to the present. Courts and lawyers have been central, again, as Scott said. More than 100 law firms, public interest and private, paid and pro bono, as well as state and local government lawyers, opposed Trump's efforts to overturn the 2020 election, which is what Scott was talking about. They won virtually every case, which says something about the quality of the lawsuits and especially about the quality of the lawyers. One of the fears is that in the second Trump term, the lawyers would be better. More than 200 lawyers and law firms defended public health measures during the pandemic, and largely sought to defend the public health measures that were in place, although the judges split along party lines. And more than 600 lawyers and law firms, led by the ACLU, opposed Trump's unlawful actions against immigrants, invalidating all but one, the 3rd of the Muslim bans. And here, too, exposing the extreme partisan divide among the judges. In each of these 3 domains, elections, the pandemic, and immigration. In each of these 3 domains, I did a rather crude study in which I used the party of the appointing president of a federal judge as a proxy for the federal judge's own political orientation, which I think is a pretty good proxy, and then whether the judge in the end favored the government, in this case the Trump administration, or opposed it. Using that mechanism, I found that the correlation between the party of the opposing president and the vote of the federal judge was 0.00001. I'm sure there are statisticians in the audience who know more about this than I do, but that's a 1 in 100,000 chance of it being merely random. It's a very high level of significance. And I want you to keep that in mind when I come back to other issues. State courts played a lesser, though important, role in election and pandemic cases, and also revealed the effects of partisan judicial selection by elections and by gubernatorial appointment. There is ample evidence that these partisan differences are continuing to play out in the two special prosecution cases, Chutkan in D.C. and Cannon in Florida. I can't imagine two more different judges. The Department of Justice is a closely related arena. Obama's holdover acting Attorney General, Sally Yates, refused to defend Trump's first Muslim ban and was promptly fired. Attorney General Sessions recused himself in the investigation of Russian interference, much to the disgust of Trump, leading Rod Rosenstein to appoint Robert Mueller. The special counsel's report pulled its punches with respect to Trump, relying on an OLC opinion, but successfully prosecuted his cronies, Roger Stone, Michael Flynn, Paul Manafort, and Rick Gates. Attorney General Barr replaced AUSAs who recommended significant sentences, and Trump commuted and pardoned all four. Trump fired the FBI director, James Comey, for not backing off his Russia investigations, but refrained from firing his successor, Christopher Wray, who declared that he found no fraud that would change the election result. And when Wray was charged as a Democratic tool, he said, just look at my background. There's nothing Democratic in my background at all. As Trump's efforts to overturn the election became more outrageous, the ones that Scott has just described, Barr resigned. He resigned because he saw the days were numbered and he was trying to create a record that would redeem himself. And his replacements, Jeffrey Rosen and Richard Donahue, as well as the DOJ division heads, threatened to do the same if Trump installed Jeffrey Clark, and that's something that Scott has referred to. Interestingly, Donahue and Rosen have just testified in the disciplinary investigation against Clark in D.C. Other DOJ lawyers resigned. Nora Danahy from the Durham investigation, Jeffrey Berman over the Hallbank investigation, and Byung Pak over the Georgia election investigation. Attorney General Merrick Garland appointed special counsel Jack Smith to handle the cases concerning classified papers in the 2020 election. Robert Hur to investigate Biden's retention of papers, that was not a great success, and David Weiss to investigate Hunter Biden, which is going on as we speak. The prosecution of more than 1,300 January 6 defendants is the largest criminal case in American history. Convictions have been obtained among those 1,300 cases in all but two. That's an extraordinary record. And for me, what's most interesting is that I looked at what the DDC judges were saying in their sentencing hearings, and the views of Republican-appointed judges and Democratic-appointed judges were almost identical, so that the incredible split that I saw in the three categories of cases that I mentioned before did not happen in the context of fairly routine criminal cases where the evidence was overwhelming. I find that interesting, and it's something I hope we can come back to. There was virtually no opposition to Trump within the executive branch until the November election made it clear his days were numbered. In the last weeks of crazed efforts to overturn the result, White House counsel Pat Cipollone and Donald McGahn, campaign lawyers Justin Clark, Eric Hirschman, and Matt Morgan, and Trump's personal lawyer, Jay Sekulow, all pushed back. And this is an interesting phenomenon, that there were lawyers who were closely wedded to Trump and MAGA, but by this point, they decided that the cause was hopeless. Most notably, after 4 years of servile loyalty to Trump, Mike Pence, a lawyer himself, certified Biden's victory on the advice of his lawyer, Gregory Jacob, and J. Michael Ludwig for whom John Eastman had clerked. So there's a very interesting connections among all of these people. Congress, paralyzed by partisanship, has been much less successful in resisting autocracy. Although Democrats chose highly qualified lawyers to lead both impeachments, Adam Schiff and Jason Crow in the first, Jamie Raskin, Diana DeGette, David Cicilline, Joaquin Castro, Eric Swalwell, Ted Lieu, Stacey Paskett, Madeleine Dean, and Joe Neguse in the second, Republican senators blocked both convictions. But it is noteworthy that none of the lawyers who represented Trump in his first impeachment were willing to do so in his second. Again, this relates to Scott's point, which is that the mainstream establishment lawyers pulled back. Not even, I can't refrain from saying it, Alan Dershowitz. When it assembled following the January 6th riot, Congress certified Biden's electoral college victory, but over the votes of 8 Republican senators, including Hawley, Cruz, and Kennedy, law graduates of Yale, Harvard, and Virginia, not UCLA, and 139 representatives. Congress passed the Electoral Count Reform Act, but Republicans blocked the passage of the John Lewis Voting Rights Act. Republicans blocked a bipartisan commission to investigate January 6th and proposed representatives who themselves were implicated in January 6th, which the Democrats refused to accept. But the special committee, including lawyers Jamie Raskin, Liz Cheney, Adam Schiff, and Zoe Lofgren, and a huge staff, produced riveting televised hearings and a comprehensive report. Democratic representatives have opposed politically inspired efforts to impeach Alejandro Mayorkas and Joe Biden and to investigate Hunter Biden. And Jamie Raskin very generously wrote a foreword to the third volume, How Autocrats Seek Power. State and local governments are playing an increasingly significant role. The massive RICO prosecution launched by Fulton County DA Fani Willis secured guilty pleas by Scott Hall, a bail bondsman, and 3 of the lawyers that Scott Cummings, my colleague, described, Sidney Powell, Kenneth Chesebro, another Harvard alumnus, and Jenna Ellis. But the future of the case has been placed in question, as you all know, by allegations of improper conduct, and the outcome so far is that Nathan Ward has stepped down, but there is an appeal from the decision by Judge McAfee, and we don't know the outcome. New York Attorney General Letitia James won a striking victory against Trump before Judge Engoron, and of course the terms of the bond on appeal are still in controversy, but at the moment he is slated to pay a judgment of almost $500 million. Manhattan DA Alvin Bragg is about to try the hush money case before Judge Mershon, and I'm very pleased to see that Judge Mershon is being very tough on Trump. I happened to have dinner with one of my brothers-in-law who was a public defender in New York for the last 40 years and who's had the misfortune of appearing before Judge Mershon on many occasions in which Judge Mershon has shouted at him. And although I felt sorry for my brother Tommy, I'm delighted that this is a judge who is tough on defense lawyers, and Mershon has shown himself capable of doing that. Alan Weisselberg's plea to felony perjury may strengthen the case, and state and local government officials in several jurisdictions have refused to bend to Trump's will, most notably Secretary of State Brad Raffensperger, Georgia Governor Brian Kemp, and Lieutenant Governor Jeff Duncan. However, the Supreme Court has just ended state challenges under the 14th Amendment, as you know. Finally, and for the purposes of time, Kathy, I'm almost done. Finally, a wide array of civil society institutions have played significant roles. Lawyers demonstrated at airports and in cities against the first Muslim ban. State and local bar associations have disciplined several of Trump's lawyers, as Scott has described, and more disciplinary proceedings are in course. Prominent conservative lawyers have publicly criticized Trump's actions, and some have helped to form bipartisan organizations like Lawyers Defending American Democracy. Legal academics have used their expertise to litigate, address the media, and publish. One of the surprising successes has been the use of defamation law. E. Jean Carroll's against Trump, almost $100 million. Ruby Freeman and Shay Moss against Rudy Giuliani, which has bankrupted him. Dominion's against Fox, which cost them almost $1 billion, and other pending and recently completed actions. a Republican computer geek successfully compelled Mike Lindell to pay up on his $5 million challenge to disprove election fraud. That laundry list is neither comprehensive nor tightly organized, but I hope it will inspire some of you to pursue its leads, to become lawyers who resist autocracy, and to document the efforts of American lawyers to oppose autocracy and preserve liberal democracy. Thank you.
Thank you. Well, thank you to everyone. It's a pleasure to be here. My name is Sofia Bordin-Rolim. I'm a PhD candidate at FGV Law School in São Paulo. The paper that I'm going to present today is part of a study that was conducted by me along with professors Raquel Pimenta and Marta Machado from FGV São Paulo Law School and Professor Débora Maciel from sociology at Unifesp. It focuses on lawyer-led resistance happening outside the institutional sphere where lawyers normally practice law, so lawyer resistance on the streets, and it focuses on one specific episode of contention, which is the August 11th episode, a set of public actions in defense of democracy that happened in 2022. So under the presidency of Jair Bolsonaro, Brazil underwent a process of democratic erosion where we saw threats to independent powers, dismantlement of public policies, attempts to close down contestation or opposition, encouragements to police violence, plans for an attempted coup, and other legal and infra-legal measures that challenged fundamental rights and the rule of law itself. Since the beginning of his term, there was always social mobilization. So there were street protests by the Black movement, by the women's movement. There were strikes by precarious app workers. There were indigenous peoples in the Amazon region who created self-defense brigades to defend their territories against the actions of illegal miners. But those were mostly very localized mobilizations, led mostly by the population groups that were specifically most affected by Bolsonaro's policies. And in 2021, so 1 year before the presidential elections, we saw an escalation of Bolsonaro's authoritarianism. So 1 year before the end of his first term, he radicalized his campaign against the federal Supreme Court and the Brazilian electoral system, which presented as obstacles to the continuity of his authoritarian project. Bolsonaro started explicitly saying that if the election results gave the victory to any other candidate, then that would mean that the election was fraudulent, so he really escalated the threats of not accepting the election results if he were not reelected. So in response to this increasingly dangerous scenario, we see something different happening in social mobilization, and that was the building of a broad coalition in favor of democracy, which gathered economic elites, legal elites, academic elites, as well as unions, civil society organizations, and social movements, which all came together on August 11th in a public demonstration at the University of São Paulo Law School. And this episode is relevant not only to those studying social mobilization, but also to those who study the legal profession and mobilization by lawyers in particular, because not only did this event take place on August 11th, which in Brazil is the date that marks the creation of law schools in the country, it's popularly known as Lawyers' Day, and not only because it was organized and articulated mostly by lawyers, but because it leans and builds on a longer tradition of lawyer-led resistance against state authoritarianism in Brazil. And that's why we're taking a quick step back to 1977 to talk about an episode of resistance which happened then during the military dictatorship in the country. So the Brazilian dictatorship always received substantial support within the legal profession. It was a very legalist regime, but also among lawyers it encountered important resistance. And so against the military regime, a group of lawyers came up with the letter to the Brazilians, the Carta aos Brasileiros, which also became known as the Letter of 1977, which was a manifesto that denounced the illegitimacy of the authoritarian governments and called for a return to the rule of law and the convocation of a national constituent assembly to end the military regime. Several prominent members of the legal community signed this letter, which was read at a public reading at the patio of the University of São Paulo Law School in 1977. This letter to the Brazilians was the most impactful public manifestation of the legal community against the military regime, and that made the date of August 11th gain an even more political meaning during the military dictatorship because of the reading of this letter. a political meaning which is then reclaimed and restored in 2022 when a new letter to the Brazilians is written. So the August 11th, 2022 episode, which explicitly echoes the 1977 episode, was a set of public actions to defend democracy, which included launching manifestos in the press, gathering signatures for those manifestos, having a public reading of them at the USP Law School, as well as street protests in favor of the rule of law. These demonstrations were articulated by two different mobilization fronts, one with the protagonism of members of the economic elite and one of the legal elite. And each one of these mobilization fronts came up with a public manifesto against authoritarianism and in favor of democracy, which were both read aloud on August 11th. So there were two manifestos. The first one was the Manifesto in Defense of Democracy and Justice, which was led by this more economic elite part. It became known as the Fiesp and Febraban Manifesto in reference to the Federation of Industries of São Paulo and the National Federation of Banks, or simply the Business Association Manifesto, and also the letter to the Brazilian women and men, which was written by the legal community, mostly by former students of the USP Law School. And the public reading of these manifestos, that was the final stage of a mobilization that had been going on for weeks and which had publicized the text of the letter to Brazilian men and women in order to gain more signatures to that letter. And this was done through a very successful online diffusion campaign and also with the support of the mainstream media. So on the eve of the public reading of this manifesto, the letter had gathered over 850,000 signatures. And the public reading, the public readings of the two manifestos occurred at different times and places at the School of Law. First, there was the reading of the Business Association Manifesto at the law school's auditorium, and then the letter to Brazilian women and men was read at the courtyard of the School of Law in the same place where the letter of 1977 had been read out loud 45 years ago. The two mobilization fronts, they were very careful to choose designated readers for their manifestos who had no links to opposition candidates for the presidency of the Republic. And they also maintained this strategy of advocating in favor of democracy and rule of law, but not mentioning explicitly neither Bolsonaro nor his mandate, and also of not mentioning now President Lula, who was the main opposition candidate at that time. And the popular attendance to the public readings on August 11th, it overflowed the limits of the law school building in São Paulo, so thousands of people remained on the streets in the surroundings of the law school to demonstrate and to watch from these big screens that were put up, to watch the speeches being delivered and also the readings of the manifesto. There were speeches that were being given from the balcony of the law school's entrance that had been transformed into this podium, talking to the people who were on the streets. And unexpectedly, on the same day, because of the repercussion of this event, public readings of the letter to Brazilian men and women and street demonstrations in favor of democracy and rule of law spread across the country. So there were public readings in 50 cities with street protests following. That includes almost all the capitals of the country. And with the national impact of this event, the letter reached its peak with over 1 million signatures. It was a group of prominent former University of São Paulo Law School students, the University of São Paulo Law School dean, and key people in NGOs who were already actively working against Bolsonaro's authoritarian agenda that were instrumental in articulating this event and bringing together this very diverse group, so economic elites, legal elites, and the social movements also showing up in support. So these very heterogeneous actors gathered around this idea of support for democracy and rule of law, but their understanding of these concepts is varied. So these groups mobilize different master frames of democracy. So first, the Manifesto in Defense of Democracy and Justice, the Business Association Manifesto, their master frame of democracy was based on the rule of law as obedience to the rules of the game, to legal certainty and separation of powers. This conception was in the text of the manifesto and can be seen clearly in the speech by the then president of Fiesp. This is a quote from a newspaper interview. It's saying it's natural for Fiesp to sign a manifesto in defense of democracy since there is no liberalism, market economy, or private property without legal certainty, whose essential pillar is democracy and rule of law. On the other hand, the letter to Brazilians, to Brazilian men and women in defense of democracy and rule of law, adapts the letter of 1977 to the present times of the Brazilian democracy. And it does so by broadening the meaning of democracy, as well as by expanding the collection of signatures outside the boundaries of the legal community, because in 1977 it was restricted to the legal community. So the democratic rule of law master frame combines this contained conception of democracy central to the Business Association Manifesto with a broader conception of democracy as a guarantee of fundamental rights, social equality, and diversity of identities of race, gender, and sexual orientation. The master frame of democracy as diversity, which was repeatedly attacked by Bolsonaro, then President of the Republic, and by his supporters, this is what guided the choice of the main characters in the ritual reading of the letter on August 11th, and is illustrated by this quote of a speech given by Manuela Moraes, who is a black woman, an undergraduate law student who presided the University of São Paulo's Law Students Academic Center and who gave a speech at that day. She says that at that August 11th, that should be an assembly in which we should make a collective pact to think beyond the democracy that currently exists. We're not interested in the democracy of hunger, the democracy of police slaughters, or the democracy of the rich. We want the antithesis of the democracy that we have today. We want a democracy of diversity, a democracy of the workers, a real democracy. Since Bolsonaro first got elected, this was the first time that such a diverse group of elite and non-elite actors came together in the same united front, a broad coalition which was then labeled the Democratic Fields. This is no small accomplishment, as this coalition included groups with conflicting interests, such as bankers and union leaders, for example, and many groups and individuals who incurred substantial political costs by aligning themselves in support of democracy and in opposition to Bolsonaro, even though his name was never mentioned in the event. We argue that this was possible because this coalition managed to comprise different meanings for what the different groups understood to be democracy in that context, and that this mobilization had a profound impact on resistance to authoritarianism because it sent a strong signal to Bolsonaro and to the military forces, saying that there is a strong unitary bloc of elite and non-elite actors who disagree on many, many things, but who will not tolerate a coup attempt or any threat to the validity of the elections. Thank you very much.
Thank you for being here. It's very nice to see Steiner, Trubek, and other friends here. And thank you, David, for putting this together. I think after these two amazing presentations about Brazil, I don't have much to add. So I will skip several of my slides and go directly to the point of the role of the Brazilian Supreme Court in this network of defense of the Brazilian democracy. So just to try to contextualize a little bit, it's important to notice that Brazil entered in a major political crisis in 2013. And this decade is polluted with hardball, institutional hardball between all members of the institutional family of the Brazilian Constitution of 1988. So Bolsonaro doesn't came as a light bulb in a blue sky. Bolsonaro is a result, in some sense, of increasing distrust on the Brazilian political system that started in 2013 with young, progressive students going to the streets of São Paulo, Rio, and other major cities, claiming basically for the fulfillment of the constitutional promises, good education, good health, transportation, so ordinary things that our tropical social democracy should provide, and that after almost 25 years, they were, even though they were a result
of the amelioration of the situation in Brazil, they were feeling the frustration because their expectations that the welfare state would be really established in Brazil. So it's interesting that the disestabilization came because of a progressive movement that started in 2013, but the streets very rapidly were occupied by a group that, since the military regime, were not on the public, on the streets, which were the far right. So with the corruption investigations and the corruption scandals and the corruptions that were being found through the Lava Jato operation, many members of the right wing that were on the shadows, they started to come to the public. And you see by the color that they adopted, the yellow and green, that we have vast demonstrations of the right wing, and not just talking about corruption, but mostly with a resentment of what the Constitution brought of good in terms of racial relationships, gays' rights, and other issues, controlling guns, environmentalism, indigenous rights. So the thing is that we had a clash of frustration by the left and resentment by the right that really squeezed the trust on the Brazilian institutions. And the result of that was the election of this far-right populist called Bolsonaro, who was a representative in the Congress for 5, I think, terms, so was a politician ingrained on the Brazilian Congress. And Bolsonaro basically used 3 strategies, and I will be focused on the one in the middle, but I think it's important to say that obviously he used the same kind of strategy that Trump used here, so it's a visceral polarization, a polarization that doesn't give space to others' discourse. And he also inciting, in most of the political science literature that we have today, just put the arms, violence, outside of the floor. It is important to understand that Bolsonaro used the tools of the autocratic legalism, but he also incited the military for a coup. So the military is a distinction, I think, among other countries that decline in terms of democracy. The military was a distinction point in the Brazilian case. They were always there. Bolsonaro was very close to them. Bolsonaro was inciting them to take part on this erosion of the Brazilian democracy. So we have visceral polarization. We have incitation of the military to overcome the democratic regime. But also we have a large part of this de-democratization process that went through law. And my concern on this research, as a constitutional lawyer, is how the counter-majoritarian institutions of the Brazilian democracy react to this autocratic that arrived to power through legitimate election. So that is the point. So first, one point of the Brazilian model, Brazil adopted in 1988 a very consensual political model. That means we have several veto points and we have institutions that counterbalance the other institutions in a very strict way. So our presidentialism, which is we have a president that is elected directly without the electoral college that you have here, it's one person, one vote, and we have a Congress that is composed by a plurality of parties. Today, I think we have 32 parties in Congress. So every president that has been elected since 1989, they have to create a coalition to govern. So it looks like a parliamentary system in the European model. So every president has to build a coalition. Cardoso, that has been a very successful president, had a coalition of 3 parties. Dilma needed a coalition of 13 parties to try to govern. So the system became more and more fragmented with more parties, and presidents were dependent on building these coalitions, and these coalitions were very costly in several senses. One is how you share power, but also how you make them elected. And the corruption scandals are linked with this, the cost of building coalitions. So I'm not going to talk anymore about the corruption, but it is part of this game, the issue of corruption, political corruption. So in my search of how the Brazilian political system reacted to the election of an autocrat is the resistance by Congress. And one of the things that we saw is that Bolsonaro was the weakest president related to Congress since the redemocratization in Brazil, in the sense that he had a terrible time to pass any legislation. He basically lost everything that he tried. So Bolsonaro wasn't able to do what Chavez did in Venezuela, an abusive constitutionalist, so change the constitution. Bolsonaro wasn't able to do what Orbán did in Hungary, pass legislation to erode democracy. So what was the way Bolsonaro moved with law? Our perspective is that he used of infralegalism, what we call autocratic infralegalism. So it's a subcategory of the general category of authoritarian legalism or abusive constitutionalism. So Bolsonaro basically used decrees. He used transformation of the agencies, cooptations of agencies. He used one thing which is, I think, is important is the nomination of people that had perspective in contradiction of the legal mission of the agency. So you put someone to head of the environmental agencies that say, I am against any kind of environmental law. So, and through this, he tried what? To neutralize constitutional law, neutralize ordinary legislation, to neutralize the democracy system through infra-constitutional and infra-legal measures. So this is what we call his toolbox, so of infra-legalism. Okay, so it's interesting, we read all the 980 decrees that he provided, where they went to, what were his targets, and it's a very interesting aspect, and we discussed it this morning, that Bolsonaro didn't have a very large spectrum of what he wanted to change. He had focus. His focus was environmental issues, indigenous people, education, and health. This was the major issues, and most of his decrees are in these areas to try to dismantle the public policies, most of them with constitutional roots, some of them with legal roots, but these were his major targets. Okay, 5 minutes. So, how the Supreme Court reacted, and I think both Fabio and Sofia talked about. The Supreme Court was in a very peculiar situation in Brazil because it has a lot of distrust from the left because of its role on the corruption investigations. But it has more distrust on the right because of its progressive jurisprudence in terms of gay rights, environmental issues, gun control, etc. So when Bolsonaro was elected, the court had its lowest point in terms of trust of the Brazilians at that time. Okay? So the first year of Bolsonaro, the court was very discreet, very deferential. We had the president of the court at that time, very ambiguous figure that proposed a kind of Republican pact to make the life of government easier. Okay? However, in February 2020, there was the beginning of the pandemic, and there was a conflict between governors who wanted to implement sound scientific solutions to combat the pandemic, and Bolsonaro was basically a Trump multiplied by 7 in terms of negating any kind of measures. So this federalist conflict was brought to the court. And the court decided in favor of states and municipalities, saying you should implement everything that you need in scientific terms to overcome the dangers of pandemic. So this intensified the conflict between Bolsonaro and the court. At the same time, the far-right groups were threatening judges. Some of the prosecutorial offices were opening investigations against justices of the Supreme Court in terms of corruption. So the Supreme Court just shifted from a very differential mode of behavior to a very conflictual mode of operation in 2000. So, and it became really to respond very fast to all demands against Bolsonaro. And here I have this graphic. I will not give the details of it, but just it's the number of days that usually the court took to analyze a case before, and then what they started to do after this shifting mode in March 2020. So it became very speed in response. So every case that was brought to the court would answer very fast. And also a thing that's very peculiar to Brazil, the court is very fragmented, and justices normally write their decisions personally. It's an individual decision. The court became very collegial, and most of the decisions were unanimous. If not unanimous, was for 10-1. So the court reprogrammed itself to control Bolsonaro. Just to finish, I think there is a very important debate in Brazil if the court went too far or not. Obviously, the court adopted most of the doctrine that you probably know called the militant democracy doctrine, written by a Jewish jurist in the 30s called Loewenstein, saying that the court should be protective and do whatever it was possible to contain. So here there are several cases that I will not analyze because I have just 1 minute, where the court faced Bolsonaro. So the most important thing is perhaps large investigation about the activities of the far right. And I will come to this quotation of Justice Fachin, who was the rapporteur for the case when was decided if the court could or could not handle investigations about the far right activities. Because it's interesting that the court initiated investigate by itself. Okay, so the discussion was, wow, can the court do this? It's not the role of the police, not the role of the prosecutorial office. And his first argument for this is that the prosecutorial office and the police are not doing their job. So the omission of these two actors, which are important to mobilize the court, is something that trigger our capacity to promote some kind of investigation. So this is one of the debates that we have in Brazil. Final paragraph is, even though US and Brazil are threatened by the same kind of forces of populism, I think the behavior of the Brazilian institutions are completely different in some sense, okay? We have already the president being found guilty by abuse of his political power on elections, with the sanction that he cannot be elected for the next 8 years. And then we have the president involved now in several cases of the attempted coup of January 8th and the draft of this decree of state of defense that was the coup in December 2020. So probably what we're going to see in the next few months is President Bolsonaro being found guilty, and not just President Bolsonaro, but also the head of the military, in several generals that will be involved on this case. So this is the peculiarity, and this is, I think, the role which is very interesting of the Brazilian judiciary during this conflict. Thank you for going too far.
Well, I want to join everybody in thanking the center for hosting us. And I hope everybody noticed that the only country that David had not visited on his world tour was Russia, right? And that's hardly an accident. So I think the thing that distinguishes Russia from the other cases that we've been talking about today is that Russian lawyers are not really an elite. And they don't matter in the same way they do in the United States or Brazil and potentially in China. Leah will tell us more about that. And so I wanted to just start with a little bit of an overview of the story of the Russian legal profession. And to some extent, they're a little bit of a late developer, that we don't really have anything going on with an organized legal profession until the 1864, the Great Reforms of 1864, and that even after that, they become a very fragmented profession. So that it's, as I say here, do we have a profession or should we be speaking of professions? That Russians who are doing legal work tend not to identify as a lawyer, but rather as a defense lawyer or as a prosecutor or as a notary. And that's not unique to Russia, for sure. And so the Bar Association, which becomes a very important explanatory variable in Scott's paper about the United States, for example, includes only a very small percentage of people who we would identify as working as lawyers. Only these advocati, and that there's a fascinating story of the advocati, these defense lawyers, trying to, get a monopoly, as we have in the United States, and that this has gone back and forth, and they've been remarkably unsuccessful in getting this, in forcing other people to join them. And so as a result, for most of the people who are working as what we would think of as lawyers in Russia, they have no ethical obligations to anybody. There's no attorney-client privilege. There's, it's just a very interesting, and in fact, that's part of the argument about why they don't want to join the advocati, because, oh my God, then we'd have these obligations, right? Not to say that they're underhanded or anything like that, but it's just sort of interesting. And so let's turn then to the question of representing political activists in Russia. And this is a story where there's always been a handful of incredibly courageous advocati who are engaged in this work, and probably dates back further than this, but a great example of it is the response to the 5-minute protest to the Red Army's invasion of Czechoslovakia in 1968. You had these people who were on Red Square protesting, and you had some, amazingly courageous advocati who had to be approved by the KGB in order to do this. You had to be on an access list. So it's not just anybody that could do it. And you wouldn't be surprised to learn that most of the people on that list were not interested in mounting a very zealous defense. But there were a few that were willing to do it. And they would make this argument that you could, because the constitutions of the Soviet period had language about the freedom of assembly. And so they would make that argument, and the court very clearly said that someone's turned off the lights. Said that, well, that's not how we understand it, and that conflicts with your duty as a Soviet citizen, and so that was the end of that story. But there is that tradition, right? And so if we fast forward to more the present day, we think about it, for the students, the very few students that are left in the room, I realize that 2011, 2012, I don't know, maybe you were in grade school or whatever, but to the older people in the room, this feels like yesterday. And so these were these huge protests against the irregularities in the presidential and legislative elections. And once again, you see the colored of them, that it's a white story there. And so you made these same arguments with the same results, that the courts weren't interested in these kind of lofty arguments. The difference now is that then you could have the next appeal to the European Court of Human Rights. And there were moral victories, and so there was some ability to get some kind of accountability or satisfaction. So the question that that I'm interested in is, how were these protests different? For one thing, there were just a lot more people arrested. And so the relatively small group of these advocati who were willing to represent folks in these cases, there just weren't enough of them. right? Now that you're required to have this advocat if you're arrested under the criminal code, but a lot of folks were arrested under the Administrative Procedures Act, the Administrative Violations Act, and then you don't need an advocate. You can have any kind of lawyer or no lawyer, right? And so as I say, the consequences here were they overwhelmed the number of advocati, and instead we started to have these folks who were not advocati, who maybe, some of them were litigators, but litigated mostly in either administrative or civil claims, and they came in, and they did not have the same kind of mindset as the advocati. They were not there to make lofty arguments. They were there simply to get their clients out of trouble. And so they would often parse the file and find some kind of technical violation that had been made by the police or the investigators or something like that, and then be able to get their clients at least sent back for further investigation. As you probably know, the conviction rate in Russia is extremely high, and that's a whole separate topic about why that is, and happy to talk about that. But the sending it back for investigation is a face-saving way for the for judges to get around the basically prohibition on acquittals. But the thing that I think is interesting among the studies that have been done of the motivations of these lawyers is that these non-advocati, these people that were getting their folks out of trouble, they do not see themselves as political actors. They're not doing this. They're just acting to defend their client. They're not resisting authoritarianism. And so I think that's the difference that I want to put on the table here, is that they're defenders, but not necessarily resistors. And then so if we fast forward again to even more, right up to the present day, to the post-invasion story, we see that the regime's tactics have become even more aimed at muffling civil society. We have this series of laws, and I have a quote from my friend Grigori here about the nature of the vagueness of these laws, how absurd it is that you just cannot know what the law means. And this is a big tactic, at least in the whole history of Russia, the Soviet period, the Tsarist period, and I would expect that in other authoritarian countries, this is also a major tactic, is just to have laws where you can say, well, I'm not being repressive here, I'm just following the law. What's the problem, right? But the reality is the law can mean anything you want it to mean, right? And so they've been able to do this. And so here we see the famous cases of people standing up with a white piece of paper that has asterisks with the number of letters to say no to war, right? And then eventually we got to the absurdity of just holding up a piece of paper, and that was also considered to be a problem. And here we see this story of someone, a guy's daughter having put a picture, and somehow he gets arrested for his daughter's picture. So lots of arrests and a very effective job of stifling at least mass protests. And there's a very interesting story of all kinds of covert ways of trying to continue to push an anti-war agenda. But it's a little bit like a whack-a-mole, because as one of these gets started, then the regime figures it out and goes after it and so on. So the response of Russia's lawyers has been spearheaded by this very elite group of advocati, of these defense lawyers, who continue to push back in a way that we would appreciate as being truly resistance. So they challenge the constitutionality of these new laws, and here we see amazing consistency, right? That the Russian Constitutional Court is simply not going to tolerate anything like this. And so at one point, of course, we had a possibility to appeal to the European Court of Human Rights, and here we see Navalny sitting in Strasbourg for his case. And the European Court of Human Rights was just as consistent in terms of ruling against Russia. But this has become a non-issue, because Russia post-invasion is no longer part of the European Court of Human Rights. So then one question for the future is what's left, right? Okay, so let's talk a little bit about the reasons why you would have lawyers taking this different tactic of being defenders and not resistors. We can say that there is a legitimate fear of state repercussions. And I think that when we track the story of the defense by bar associations of the advocati when they push back too hard, it's not a pretty story, but it's not as bad as you might suspect, right? There's been a fair amount of defense and more recently, less defense, right, of lawyers engaged in this. And some kind of tactics that we're familiar with from the China example, where you arrest lawyers for basically doing their job. And because in doing their job, they have to say anti-regime things. And so all of a sudden now they're in trouble as well. I think a big part of it is simply the fragmentation of the legal profession. And if you're not part of the advocatura, you have no protection, right? You have not only, you have the advantage of not having any ethics, but then you don't have anybody to help you out when perhaps you run afoul of people. And then the other thing is what I alluded to earlier is this almost pointlessness of trying to push back, because what we tend to refer to in the Russian case is the accusatorial bias. And this is a story that a lot of people assume is about repression, that the reason why you don't have more acquittals in the Russian system has to be because the regime is pushing for convictions. And, of course, that's not irrelevant. But the bigger story here is really an HR problem, right? That the way that judges and prosecutors are evaluated is on a set of quantitative indicators that have, no room for, quibbling about it. And so if you have a lot of acquittals, then that just looks very bad for you. And so they try to avoid that. And they find these ways to try to deal with some of the equitable issues in terms of sending things back for further investigation. And I have to say that to me, one of the things that's striking about the Russian case is just simply the lack of role models. That if you want to be this kind of lawyer, is that something that is modeled for you in any way? For our lawyers, for our law students, we have tons of examples of this kind of thing, and that just is fairly few and far between in the Russian case. So I'll leave you with that, and I guess in the Russian case, it's always a sad story, isn't it? And so, but could be sadder, that's what we have to say. It can always be worse. That's the motto of the people who study Russia. Thanks.
Hi, everyone. Good afternoon. My name is Leah Kraut. I am the acting executive director of the Newcomb Center for the Rule of Law at Stanford Law School. And I am also, as David kindly noted, an incoming associate professor at Syracuse Law School in the fall. The paper that I'll share with you this afternoon discusses legal mobilization against authoritarianism in the context of three distinctive states: the United States, Brazil, and China. In this paper, I summarized many of the findings of our predecessor organization called GRAD, Global Resistance to Authoritarian Diffusion, as well as making some generalized summaries about what we can find in common in these three distinctive regimes when they choose to resist, when lawyers do choose to resist authoritarianism. Oh, and this is a work in progress. We are working together with the GRAD authors to complete these reports, and I also have an additional question that I will go over in relation to bar associations that I'll define further as we continue. Before I get too far into the substance of today's talk, I'll just provide a brief roadmap. First, I'll begin with an introduction of how we got to where we are in terms of democratic erosion. Many of my colleagues have already talked about this in depth in relation to their specific countries of focus, but I'll provide more of a bird's eye view to create a collective and unified picture. Next, I'll move on to the case studies, why I've selected the countries that I have, and how we can find points of collaboration or points of correlation in legal methodologies implemented to resist authoritarian leaders. And finally, I'll discuss whether or not bar associations, in particular independent and consolidated bar associations, can and do indeed have an impact on legal mobilization. This, however, is incomplete, so I'll just share with you a couple hypotheses that I've developed thus far in relation to bar associations and legal mobilization. Okay. First, an introduction into how we got to where we are in relation to democratic decline. Most, if not all, human rights or rule of law indices have indicated that we are currently in an era of democratic decline. This is a little bit contested. Levitsky and Way, for example, argue that perhaps this is a little bit overstated, and perhaps we're not in an area of democratic decline, but we are in an area of lost expectations or failed expectations. But for many of us who lived through or studied the period of democratic optimism from the 1980s to the early 2000s, this is very surprising. During this period, many different regimes throughout Latin America and in Eastern Europe, for example, seemed to be on the verge of transition to democratic states, and many had implemented what Pierre and Boom would call a thin rule of law system, wherein some of the core features for implementing a thick rule of law, one that promotes and protects human rights, could be on the track to be implemented. However, in the early 2000s to 2010s, we start to see a troubling resurgence of authoritarian leadership. One of the earliest individuals who began to use the law in the way that we are seeing it used today was Hugo Chavez in Venezuela, who very famously implemented a procedurally deficient popular referendum to change the constitutional order of a young democracy in Venezuela. This was also copied by Rafael Correa in Ecuador, and it spread throughout the world, and we saw a reversion from the promotion of international institutions, the promotion of accountability for human rights and democracy, back towards national sovereignty and lack of accountability for these violations. That brings us to today, where we see a concentrated use of the law by authoritarians, laws that respect the law's character but not its spirit, that are enacted to ensure that the authoritarians keep their grasp on power. This is what Kim Lane Shipley and others call authoritarian legality, autocratic legalism, and this is our current era of democratic decline. Okay. Much of the literature that has focused on this area so far has focused on how we've gotten to this point. We look at how the authoritarians are abusing the law, how are they maintaining their positions. However, we've not really looked into how we can resist, and this is where the work of the GRAD and the LAD coalitions come in, and this is where this chapter focuses in on. We need to look now at the grassroots efforts to reject these authoritarians and ensure that their actions are appropriately prosecuted. This brings us to the role of lawyers. The role of lawyers is complex, as my colleagues have noted. On the two ends of the extremes, first, there are lawyers who promote the organization. An interesting aspect of some of the individuals who we view as key autocrats today, Donald Trump, Jair Bolsonaro, Narendra Modi, they lack legal expertise. Lawyers are needed to implement the type of regime that will allow them to stay in power indefinitely and achieve their intended goals. Therefore, we see a select coalition of lawyers who act in support of these types of regimes. On the other end of the extreme, however, we see lawyers who are acting to resist authoritarian leadership. One of the key examples we typically think of is the 2008 lawyers' movement in Pakistan, where the entire bar fundamentally mobilized to protest the extra-constitutional suspension of Chief Justice Chowdhury under President Musharraf's regime. Because of the bar's collective mobilization, in part, the extra-constitutional suspension was lifted and the Chief Justice was able to resume his position. Another more contemporary example is seen in the photo that I've included here. This is a photo of Hong Kong lawyers who are walking out on the middle of the work week. I believe it was on a Wednesday. Dressed in their formal wear, they left their law firms in a show of solidarity against the Beijing takeover of Hong Kong's government. There is also a third category of lawyers who, as Kathy mentioned, not everyone is always on either end of the spectrum. There are some who act in their own self-interest and don't participate on either forum. However, for the purposes of this chapter, we focus more on the lawyers who, like in the picture here, are promoting or rejecting authoritarian leadership. This brings us to the types of different legal mobilization. Here I use a modified categorization of what was created by Lynette Chua in her article on legal mobilization under authoritarianism. And there are three types that I use here when reviewing the case studies. The first is formal legal mobilization. And this relates to what we typically think of when we think of legal mobilization. We think of lawyers defending the wrongfully prosecuted political prisoner. We think of individuals promoting pro-democracy legislation, among other examples. The quasi-formal category relates to forums that are legal in nature but don't have the same impact as perhaps a court case or pro-democracy legislation might. Mary Gallagher, in the context of China, brought up a good example of day laborers in Shanghai consulting with legal aid organizations and becoming more aware of their rights and potentially being more empowered to bring legal suit at a later time or to negotiate more informally with their employers to ensure that their rights are respected. In the non-formal context, this relates more to political mobilization. How are lawyers or individuals with legal-oriented goals participating in less formal fora to promote pro-democracy or anti-authoritarian ideals? So in relation to our case studies, I selected three from many of the different grad countries that were our areas of focus. The first is the United States. The United States, under the Varieties of Democracy or VDEM Index, is actually considered an electoral democracy, which is a step below a liberal democracy. So we've slid a little bit, of course, over the past couple of years. But for the purposes of this study, we're going to give it the 10th of a point that it needs to bump it to the liberal democracy. Yeah, that's true. Yeah, I'm anticipating a good election year, right? Anyway, in relation to Brazil, this is placed more firmly by VDEM in the area of electoral democracy. And finally, China is considered a closed autocracy. So the reason behind the selection of these three case studies is, one, their geographical difference, and two, the distinction in their regime types. These two elements will allow us to see with relative clarity whether or not we can find any areas of correlation or where there are joint methods or joint successful methods of legal mobilization against authoritarian leaders. And I'll provide just a few examples of how legal mobilization has occurred in these three different states. In the United States, this paper focuses on mobilization under the Trump regime. It is, of course, a liberal democracy, and throughout the Trump era, we saw lawyers reacting in a very particular, but not necessarily coordinated or collective way. We saw several individual challenges challenging Trump-era policies, and we saw heightened levels of political organization, but it was all a bit fragmented and not really a joint effort. In terms of different types of mobilization under the categories presented earlier, a good example of formal action was right after the publication of the entry of the Muslim ban, Trump's executive order. The over 50 challenges, were issued against this disparately throughout the United States. In the quasi-formal context, this was a little bit more limited. This didn't really come up within the scope of our research. And finally, in the non-formal context, we saw a lot of activism from attorneys and from the legal profession. However, we didn't see it in a very concentrated way. We saw great deals of online activism, which was supported by individuals' colleagues, but we didn't see the force that we saw in the Brazilian context. Moving on then to Brazil. Again, Brazil is identified as an electoral democracy. We saw a great political engagement from the legal complex, which was articulated by my colleagues. And we saw different methodologies being employed by the institution as well. Both institutional and non-institutional resistance measures were mounted against Jair Bolsonaro. In terms of formal legal mobilization, we saw the court enact a true militant democracy in promotion of liberal values. The court decided very often against the state, which is a strong indicator of judicial independence and the integrity of the judiciary. Quasi-formal, just like in the United States, was limited, and non-formal, we saw great efforts from the legal complex within Brazil to mount political activism in the non-formal context and ensure as well the engagement of different civil society organizations and members. In China, however, this is a very different story. It is a closed autocracy where we have seen the total internal co-optation of the legal complex. If you are a lawyer in the People's Republic of China, you are required to become part of the bar organization within the state. The bar organization in China has 2 levels of oversight. First, we have a self-oversight where you are immediately supervised on what cases you take, what actions you take within those cases, and how you represent your clients within the profession. And also, you're overseen by the state or the party, the Communist Party of China, who also tends to dictate what cases you're able to take and how you are able to manage those. We are also seeing, however, and despite this repressive context in the legal occupation, we're seeing a lot more of external or international efforts to democratize. So individuals who either are expats from China or who are living in exile from China, especially those who are lawyers, are participating a great deal to protect those individuals who are still within China, many of their former colleagues, and also promote democracy within the state and democratic transition. For example, I recently submitted a piece to a Mandarin journal, which was based just outside of China in Taiwan, inviting scholarship that talks about how we can change the regime in China to a democratic state. Okay. In terms of mobilization against authoritarians, that has occurred recently under the Xi Jinping administration. In the formal context, it's quite limited. The judiciary, just like the Bar Association, has been captured or co-opted by the Communist Party of China. The quasi-formal methodology, however, is quite divergent. We see it's far more active than in electoral or liberal democracies, the US and Brazil. And this is potentially a good area for development in the future. We saw, again, the example of day laborers in Shanghai going to legal aid organizations, which aren't as directly controlled or regulated by the state because it's a little bit less threatening. Being able to learn more about their rights and being able to take this further on their own volition and petition for better working environment on their own behalf. Finally, in the non-formal context, we're seeing, again, increasing regional and transnational efforts, particularly by Weichuan lawyers or exiled human rights lawyers. Okay. Just briefly, some comparisons among these three distinctive states. First, formal action is an option in different democracies. We see courts still being used with relative regularity in both liberal democracies and electoral democracies throughout the world, as well as a legislature where it's possible. Quasi-formal action was effective in China, and we hypothesize perhaps it is an avenue for transition or promoting pro-democracy goals in other closed autocratic states as well, where these are where other methods of action are closed, that being formal action and non-formal action. And finally, non-formal action had mixed results, but seemed effective with cross-coordination in particular among civil society actors. Okay. And just briefly about bar associations, this is a question that is under construction within the draft. And here we're going to look into the independence of each bar association or its equivalent, whether and how each bar association is mobilized, and the factors behind divergent responses among jurisdictions to determine whether, and if so, to the extent, the existence of an independent and consolidated bar association helps or hinders legal mobilization against authoritarianism. And just to end on a few hypotheses, while lawyers often do not mobilize against authoritarianism, they can play a meaningful role in reversing democratic decline or challenging authoritarian closure. Collective mobilization is more impactful, yet far more rare than individual activism. And bar associations tend to act in their own interests and will counter authoritarianism if such leadership would threaten its industry or the profession. Jose Colon Rios has a really good piece on this in relation to judicial corporatism in Mexico, wherein the judiciary acted in a concerted way, emulating that of a corporation, to counter current President AMLO's authoritarian policies. But I'll end on that note. Thank you very much for your time.
So, wow, okay? This was really incredibly informative and impressive. We have a few minutes left, and we have 4 unbelievable, I think, students who have been with us almost the whole time. And I want to give them the opportunity, if any of you wants to ask a question of any particular thing, and obviously there was a lot that was there, or just to ask more generally, or to comment more generally from your perspective. So does anybody wanna, I see you shaking your head, I'm a professor, I might call on you first. If you don't mind, speak in the microphone and then I'll hand them. You could either direct it to a particular person or direct it general.
I'm not a student, though.
Oh, okay,
Hey.
sorry.
I'm Grigory Vaipan, a Russian human rights lawyer and a visiting researcher here at HLS this semester. So I have a question for 2 speakers who spoke about the experience of the United States. But so I'm going to ask this question using Russia as a kind of a counter example. So in Russia, we, as Kathryn has very well summarized, cannot, as human rights lawyers, very rarely or almost never can expect to actually win cases. So we use different criteria of professional success. One of which is being able to speak the truth to the public. So very often these days, Russian human rights lawyers who defend political activists, political prisoners in court, have a platform or a podium from which they can speak to the public, to the Russian people, about political persecution. And they have a legitimate, nobody can silence them in court. And it's a public hearing. So with that in mind, we heard examples of lawyers standing against authoritarian trends here in the United States and winning many cases in court. But how successful were they in actually persuading that part of the American public who voted for an autocrat? That's my question.
It's a terrific question. So Rick and Scott, I think that one of you, I know both of you have thought about this very issue. Rick, thank you.
Yeah, I mean, the American public is extraordinarily ill-informed, as I think you must realize from your time here. People don't read newspapers, they don't read books, they listen mainly to social media, and these things, of course, are not reported on social media. Very high-profile cases, like Dobbs in overturning Roe, is in the public consciousness. But aside from, and undoubtedly, the cases involving Trump are in the public consciousness because he puts them there. But if anything happens with respect to the relationship between courts, litigation, and public consciousness, it's terrible because what the public hears in social media from Trump is that the courts are corrupt, the courts are bought, the courts are doing Biden's bidding. And since that fulfills the kinds of prejudices that people come with, it further delegitimates courts. So, I mean, this has to do with the downward spiral of the legitimacy of liberal democracy. And courts, it used to be the Supreme Court had the highest prestige level of any American institution. That's certainly not true today. And most Americans know little or nothing about the 2 lower levels of federal courts. But respect for the courts is clearly declining.
So what can progressive American lawyers do about that if winning a case is not enough?
I think you just handed it.
I don't know if I can answer that question. I mean, I think I would just add to Rick's point that, I mean, one of the things that cuts across all of these conversations that we've had today but hasn't been named explicitly is the role of technology in the fragmentation of democracy and the ways in which winning in court doesn't necessarily translate to winning hearts and minds, right? And because people are getting 2 different types of information, and I think overcoming that particular problem is something that I don't know the answer to. Lots of smart people have thought about, but it is something that I think is a fundamental barrier to the kind of classical social change model where you would have social movements, legal mobilization that would actually create a public narrative that could be bought into by most people, and that would actually translate into cultural change and legal change, or we're not in that moment anymore. So I think speaking truth to power remains essential. Sort of, you know, that's what lawyers have to do across these political battles. But you know, how to translate that, I think, is a really important question that is really, really complicated and hard for me to answer.
Anyone else here of our valiant, or who may or may not be students? I'm not making any more assumptions anymore. Any other? And you don't, I'm not going to call on anybody, but you guys have heard a lot. I, of course, have questions. Please, thank you.
I have to disappoint you, I'm also not a student.
All right, I'm thrilled that anybody's here.
Thank you. Thank you so much for putting this together. I'm a visiting fellow at the Ash Center. And yeah, I was really delighted to hear all the talks today. And I'm studying actually actors in protests, so on the street protests. And what we see there is also that an important type of actor category, I'm calling it that because I'm doing a lot of statistical analysis on that side, are actually lawyers and advocati in the Russian case themselves who step out on the street, especially in those cases when the people that they speak for have been arrested. So I don't know if any one of you would be interested in speaking to that. What happens if the people you're representing get arrested or disappear or are tortured at the hands of an autocratic government? Do lawyers have a specific role in that moment? And how do you think maybe does that contribute to winning hearts and minds, and that they have this special podium to speak from?
Thank you. And for those who don't know, the Ash Center is at the Kennedy School.
Thank you so much.
Go ahead, Kathy.
Well, Grigori may want to augment what I'm saying here, but in Russia you have a constitutional right to defense. And so you have a right to an advocate if you're arrested for a criminal charge. But there's ways of getting around that for the regime. And even when you are arrested on a criminal charge, it's not like they lay out the red carpet for the advocati. There's a lot of work having been done on the obstructionist tactics that the police and the investigators use in order to keep their clients away from their lawyers for long periods of time. So it's not an easy thing. Now, one of the things that happened in the 2011-2012 period that this wonderful dissertation by Renata Mustafina, she has a very nice article on publicity in Law and Society Review, but she documented how during the period where a lot of these folks, especially the folks that weren't arrested on criminal charges but on administrative charges, were showing up at the courthouse, and they had no idea, kind of what they were supposed to do, that they had teams of people there that were organized by human rights organizations to try to, walk them through what are the expectations, what should you be doing, and that kind of thing. So I think that can be very helpful. I'm not sure that that's still going on today. I think probably not.
Yes, please, because Brazil.
Thanks.
Please.
No, just a comment. Thank you for your question. I think that when we look at protests during the Bolsonaro years in Brazil, we actually didn't see that many massive street protests as we did in the years before. So during 2013, which is something that came up in Oscar's presentation, there was a huge cycle of protests with mass mobilization, over 1 million people on the streets. We didn't see that during the Bolsonaro years, and there are many reasons for that. But I think that one of the main ones is that people were afraid. They were scared of what the police would do under the Bolsonaro government, and because of Bolsonaro's speech against activism and against street protests, that was in itself a way of repressing collective action by preventing it from happening even before people took to the streets. And in the context where there was collective action, which was severely repressed, that's mostly outside the context of the large urban center. So when we're looking at indigenous mobilization or mobilization in the countryside, then we do have very strong and violent repression, but that often used, for instance, non-state actors. So we have illegal miners and people related to farmers repressing protests in the Amazon region, for instance. Then it's not like an official state actor that's going to take you to through the whole official procedure of detention and calling up your lawyer and so on and so forth. But during the 2013 mass protests, we definitely saw there was a big role played by popular attorneys and people defending the demonstrators, and there were a lot of tactics that the police implemented to make it harder for those lawyers to reach their clients. So they would take people under arrest and not tell the lawyers to which police station these people were being taken to, and would take them to like police stations that were really far away to make it difficult for the lawyers to reach them and that kind of thing.
I think, can we get one more question? Yeah, here, I'm sorry, Oscar. Yeah, I'll just say that when I was in Brazil the last time, hundreds of thousands of people were marching down Avenue Paulista to bring back Bolsonaro and to protest his being barred from the election.
So this is actually for the Brazilian lawyers. So my name's Greg Beyer, and I'm writing a book about the relationship between markets, politics, and technology, and how they can work together to build a sustainable future. And in the case of Brazil, and I'm also a sustainable investor, fund manager. And so in the case of Brazil, I was astonished when Brazil was auctioning its oil fields, and none of the international majors showed up, not even China, zero, nobody came. Yeah, and the next day, a few years ago, and maybe in 2021, I can't remember exactly, it was just a few years ago, but they were auctioning the major, and the same day or the next day, the Supreme Court of Brazil started the process that got Lula out of jail. Now, I felt that there was somehow an agreement amongst the elites that because Bolsonaro had completely failed to auction these fields, of which for sure they were definitely going to get paid out on, in my view of the way things work in emerging markets, I feel like Bolsonaro couldn't deliver, so he lost his job, and they brought Lula in. And so I'm curious, and I didn't hear anybody talk about how Lula was brought out of jail by the Supreme Court today. And I'm just wondering what your thoughts are of how that maybe could have happened, because that's just been a big question mark for me for some time.
So why don't we say Oscar and then also Fabio? And then I think we'll probably have to close with this amazing session. Please, go ahead.
All right, so the corruption scandal that started to be investigated in 2007, there's one, and then 2014, you have another section of it, okay? And Operação Lava Jato was this major investigation that brought into the Brazilian legal system the plea bargain. We'd never had this before, okay? So with the plea bargain, the number of people that get involved was extremely large. In the first round, most of the left-wing parties were caught under this investigation. So there was immense support from the right wing and reinforcing the position of the courts to move on the investigation. However, the investigation became larger and larger and would involved also the members of the right-wing parties. So the investigation started to lose weight and became more criticized by other sides because it really involved many other people. The Supreme Court, from my perspective, I've been written about this, was very ambiguous about oversighting this investigation. There were several habeas corpus that arrived at the Supreme Court, and the majority of the court supported 6-5 the investigations that led to the conviction of Lula. Okay? So in the end of this process, 2014, 2015, the court became to shift. Also because some of the investigators were trying to cut members of the court. So the whole Lava Jato lost the confidence of the Supreme Court. And the Supreme Court started to change its position. And one issue, which is the major relevance, is when a person could be in prison. Because the idea, the Brazilian Constitution say a person should be in prison only if it has a final decision. So what is a final decision? Is this a decision at the second instance, or is it a decision at the Supreme Court? So the Supreme Court used to say a second instance is a final, it can be considered a final decision. And that's when Lula was in prison after a second decision. And the court shift back to an old position, which was a person can only be in prison after a final decision, which is mine. So it reverted the decision that allowed the imprisonment of Lula. So I think these were the issues, legally speaking. Politically speaking, I do believe that part of the shift of the majority of the court was the perception that an autocrat would win in the end of the day, and it was absolutely necessary to bring Lula back to the game. So the shift of one of the justices, the switching time that saved the democracy, perhaps is linked to bring back Lula to the game. So I don't know, this is the political understanding of what happened there.
History doesn't repeat, but it rhymes.
No, this is a very complex issue, and I've also written about Lava Jato, this major anti-corruption case. I can send you some of the pieces. Mark has a book.
You're not getting into the oil side, because I think
Right. Yeah.
I think that was the sale of the oil fields was the catalyst.
I'm gonna add one thing to what Oscar said, and then I might come back to this issue. So I think it also helped the Supreme Court make a shift. The fact that Lava Jato itself lost a lot of legitimacy. First, because Moro, who was the judge presiding over the case, became part of Bolsonaro's cabinet. And so that was widely read as a signal of politicization of the investigation. And then because there was a series of leaked messages exchanged, yes, and then there was a series of leaked messages exchanged between the prosecutors and Moro at the time, which showed that investigation was poorly conducted. So, they essentially lost a lot of the trust that they had among the Brazilian elites. And which I think involves part of the business elite. But I think your argument, I don't know, we might have to look specifically at the oil industry, but I think it makes sense to think that some of the economic elites were not happy about the way that Bolsonaro was handling the economy, and then they supported Lula. What I think makes it difficult to think about the oil industry as being part of that elite was that Bolsonaro actually adopted a very pro-foreign companies policy during his tenure, including with something that enabled the prices for oil in Brazil to be indexed to the international oil markets, which is something that Lula reversed. So, yeah, I think it's more complicated than what you're saying. I'm happy to help you think through this.
So we could stay here forever on this. I think just this last point, which I'm not going to ask as a question because I get to talk to you guys anyway, but raises the issue of what is the relationship, if you're going to study bar associations, between what Heinz and Laumann might call the corporate hemisphere of the bar and what we might think of as the human rights hemisphere or human rights sector, which is, Heinz and Laumann said that the division between hemispheres was going to destroy the ability of bar associations to be effective mobilizations because of the split. Then Desley and Garth came back and said, no, actually they're both united around this idea of what is the rule of law. I love in the Brazilian case, the two manifestos, which as you rightly point out, are doing very interestingly different philosophies of what the rule of law is. United, as Michael Walzer might say, on a kind of thin version of democracy, that allows people to unite under things like liberty and freedom without actually defining what they are. And then you have the example of China, where when I was there, the a human rights lawyer had been arrested, and the question was, what were all those corporate lawyers with pro bono departments who were showing up at the American Bar Association saying that they were just like every other law firm recruiting students to come on the basis that what were they going to say, right? And of course, the Chinese Bar Association is run by Wang Zhongfeng, or was, who was the founder of King & Wood. Which is the largest, most important corporate law firm in China, which then tried to merge with other law firms around the world. So this question of how do we think about if we're going to talk about the bar, what are we going to think about the relationship between the corporate bar and the human rights bar? But we can't talk about that now. We should go home. This was wonderful. Can we thank our amazing researchers for everything that they've done? Thank you very much.